What's up, all my beautiful people? I hope all of y'all are doing so good. Hey, man, we just released a whole bunch of um, first-hand situations out in the real world. This is part four, of course, of the most sacred of liberties, the right to travel. Of course, I'm Cameron Wilson, and I'm the guy that you're seeing all over this channel, riding around with private plates, going to court, arguing with cops. Yeah, I'm that guy that stands up for our rights. And this is the most sacred of liberties series. This is part four. We're jumping right back into it. I want to thank you for being here. Of course, again, you always know the right to travel course is free. Um, you can catch that on my website. Links below in the description, as well as the book that I just released. So the last tread, at least on me, anyways. That is because once you know, you ain't gonna allow them to do it no more, and that's why we named it that. You can also pick that up on my website. Link is in the description. And then, as well as our traffic law reform campaign, the petition that's on change.org. And we're getting a lot of signatures from that. I've been asking people in the comments, and I just want you to know if you have any questions at all, feel free to comment. Feel free to go to my website, grab my email, and shoot me an email. My phone number is even on there. That's how much I'm really out here to support y'all. You freely call. I don't charge anything. So, with that being said, let's jump into it, y'all. So, first things first, we just diving right into it. So, the last thing that we just read was in the above case, the word traffic, which you've been seeing when I've been speaking to these cops on the road. They say, no, you're engaged in traffic, is used in conjunction with the unnecessary auto transportation service. In other words, vehicles for hire. Okay? So, we all have to understand our legalese here. This is why it's so importante. Okay? Importante. The ultimate test of the proprietary police power regulations must be found in the 14th Amendment of the U.S. Constitution, since it operates to limit. It's not to do what? It's not. I'm coming out with my constitutional rights that was given to me. No, sir. No, sir. No, sir. No. It operates to limit the field of the police power. Oh, you mean the Constitution sets limits upon its governmental agencies? Yes, Cameron. To the extent of preventing the enforcement of statutes in denial of rights that the amendment protects. Well, there we go. See, generally, Parks versus State. 159 IND 21164 NEA 62 as to the procurement of a license for the public practice of medicine. Quote, with regard particularly to the U.S. Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any state police authority. Unquote. Let's read that again for all you people that think that the police powers can come out here and dictate how regular, normal, living beings and creations of the Creator have to go out and get what y'all deem necessary and require. It says, with regard particularly to the U.S. Constitution, ain't nobody talking about no state. We talking about the big boy. It is elementary. We talking about basic now. They low dogged y'all and said elementary. That a right secured, not given, not granted, but secured, or rather protected by that document, cannot be overthrown or impaired by any state police authority. Period. That's Connolly versus Union Sewer Pipe. Lafarere versus Grand Trunk Railway of Canada. And O'Neill versus Providence Amusement. Quote, the police power of the state must be exercised in subordination to the provisions of the U.S. Constitution. So all you people out there being like, oh no, man, that's not how it works, bro. You have to. That's why they set up the 14th Amendment for police power. It only must be exercised in subordination to the provisions of the U.S. Constitution. I think we spoke about this very heavily in episode 3. Okay? And this is Buchanan versus Warley and Panhandle Eastern Pipeline Company versus State Highway Commission. Quote, it is well settled that the constitutional rights protected from invasion by the police power includes rights safeguarded both by express and implied prohibitions in the constitutions. Unquote. Touché versus Osborne. I was wanting to say touche, but I made it work. All right. Quote, as a rule, fundamental limitations of regulations under the police power are found in the spirit of the constitutions, not in the letter, although they are just as efficient as if expressed in the clearest language, unquote. I really like this quote, and I'm going to break this down just a little bit more because what it's stating in here is it's the spirit. So, the spirit and knowing of natural law, things that we can commonly feel and know that are to be true, which is, of course, the right to travel, can be wrote into, that's why he says, not in the letter, right? So, it can be wrote out, but being wrote is only one type of explanation, and that's why we have so much case law, because case law goes into the different perspectives of that fundamental God-given natural right. So you have the perspectives from different cultures, from different, just I would say cultures altogether, because race is a complex, stupid thing. So I would think just cultures. Every different culture, every different type of person that's raised in their own environment, as far as how they see it, is a different perspective. But I think all can agree on freedoms that we naturally have across the board. So I think that was really cool in that regard, because it's distinguishing the spirit of just knowing versus, the letter and what we write upon that knowing. So that's Mehlos versus City of Milwaukee. Now, the 14th Amendment does not interfere with the proper exercise of the police power, in accordance with the general principle that the power must be exercised so as not to invade unreasonably the rights guaranteed and secured by the U.S. Constitution. It is established beyond question, though, that every state's power, including the police power, is instead limited by the 14th Amendment. You see what I'm saying? So the case of Chicago versus Banker below is a cumulative ruling exercising the charger restriction, emphasizing the difference of vehicle operator from the personal private traveler, and further employing the rule expressio unias es exclusio ratorius. The case of Chicago versus Banker turned upon the question whether the city of Chicago had the power by ordinance, code, statute, and in the absence of statute, to require an automobile owner, quote, to submit to an examination and to take out a license, unquote, before he should be permitted to operate his vehicle for his private and personal pleasure. Now listen up. Hey, all of my police agencies out there, can y'all please listen up? I know some of y'all are stalking me. Please listen up. Listen, I am only trying to bridge the gap between us and all law enforcement. Believe me, I have family that's in law enforcement, and this is what they are desiring. Okay? So pay attention to this. I'm going to restart this over for everybody. The case of Chicago versus Banker turned upon the question whether the city of Chicago had the power by ordinance, and in the absence of statute, to require an automobile owner to submit to an examination and to take out a license before he should be permitted to even operate his vehicle for his own private and personal pleasure. The court, in declaring the ordinance void, held that inasmuch as there was no statutory provision on the subject, the charter of the corporation is the measure of its powers, and the enumeration of those powers implies the exclusion of all others, unquote. The law applied to motor vehicles, Babbitt, Section 32. So, in the case of Shreveport below, the city brought an action against Stringfellow for the payment of taxes on his automobile. That's what a driver's license is. That's what a registration is. That's what inspection is. Yeah. The city's claim for taxes was denied by the court because Stringfellow only had personal automobiles that were for his family's use, not for access to or by the public, galvanizing that no taxes may be levied against, and consequentially, no policy enforcement may be laid against a private traveler. It was that simple in that case, and we will go into some quotes here for that. Quote, in the case at bar, a license tax is sought to be collected from the defendant, not on account of his calling or vocation, but because he is, and not on his account of his calling or vocation, but because he is the owner of 2 motor cars. Motor cars. I wonder if we should start using motor cars instead of motor vehicles. No, sir. No, sir. No, sir. This is not a... No, sir, this is not a motor vehicle. This is a motor car. Sir. No, sir. Nope. Sir, in the city of Shreveport versus Stringfellow, it was clearly established that when we use our own personal private conveyance, it is termed a motor car. No, sir, I'm not driving a motor vehicle. If you look at motor vehicle, you see what I'm saying? But you don't got to argue with him, man. Let's keep going. But because he's the of two motor cars used by him for the convenience of himself and family, unquote. Again, this is City of Shreveport versus Stringfellow. I'm sure these are a lot of quotes that none of y'all have gotten into before. So that's what makes it really good, is that, of course, you hear a lot of other ones, but when you have so many now that we've been reading, I mean, I'm 4 episodes in, so this is going to be about, hour 4 here of reading and just thoroughly thinking. It's isn't it starting to play we're getting a good track record, aren't we? So, however, in maintaining consistency of authority, it is again reiterated that businesses fall under legislative purview, and subsequently the police power of the executive branch. It is because those who drive for a living spend a good deal of time on the roadways and therefore increase ratios of likely harm to other travelers. Here in Washington, we have several public trails that were created for the use and enjoyment of all walkers, runners, and cyclists that would choose to use them. The most popular being the Burke-Gilman Trail. These trails are used by athletes and serious health enthusiasts. This group of people would be likened to the businesses that use the highways, because it is this group that would attend the trail more frequently, as would a business use of the highway. However, there's a second group of people who would not use it so frequently and for a less convicted purpose. The people out for a sunny day walk, or a romantic stroll, or perhaps walking a dog. There is no less of an expectant right to the common use of the trail differing from the athletes, but there is the courteous and accepted reasonable regulation, i.e., calling out when coming from behind or slowing down when approaching crowded areas, or even the left side versus right side flow of movement. Quote, when the calling or profession or business is attended with danger or requires a certain degree of scientific knowledge upon which others must rely, then legislation properly steps in to impose conditions upon its exercise. It is certainly true that the business of the man who operates and propels an automobile along the public street is such a business as is above alluded to, unquote. The law applied to motor vehicles, Babbitt, section 27. Some employments in which integrity is of vital importance, it may be proper to treat as privileges merely, and to refuse the license to follow them to any who are not reputable, unquote. The law applied to motor vehicles. Due process void for vagueness. Herein, this section, it is pled that the state statutes, so we're going into a different section, y'all, are vague as to their text. The statutes do not expressly include personal use of an automobile and of their regulatory scheme. The statute makes no mention of any use other than commercial, as is indicative of the breadth of dictum set forth herein. It is a fact the state has no authority to stop and harass personal private travelers in their use of the common highways by any pretext. The state statutes do not specifically include private conduct. In so as much fact, they impliedly exclude private and personal conduct. The state has the burden of defeating all arguments herein by mandating showing that private and personal conduct can be, or is properly, within the scope of statutes hereby challenged. If the statute is silent and ambiguous with respect to the specific issue, the question for the court is whether the agency's answer is based on a permissible construction of that statute. See what I'm saying? And that's Chevron USA Inc. versus Natural Res Defense Council. That good old Chevron we've been talking about. If y'all don't know, all you literally have to do right now, y'all, is all you have to do is just go into Google or whatever search platform you use and type in Chevron deference repealed. You can put in June 2024 if you want. There are plenty of articles that go into that. I think I do have a video before I started this series, a little bit further back, maybe about a month back now, where I've gone over that. And I believe That's an update to. Oh no, that's going to be in the Right to Travel course. So you're going to have to go to the website and get the course. It's free though. You just got to sign up. You get the link. So let's go into it. The right of reasonable regulation is and this is a quote, modification of the sweeping generalization that every person has the right to pursue any lawful calling. Restrictions and regulations may be imposed within proper limits without in any way impairing the fundamental right to engage in occupations. Thus, the state may demand skill requisite with the subject matter involved for public protection in those callings. Excuse me, you're looking at me while I'm reading, and you should be on the page. We're right here. In those callings, your jobs, your business, in which incapacity would injuriously affect the public unless an act restricting the participation of a citizen in ordinary occupations can be shown to fall within the police power. Such act is void as violating the constitutional right of the citizen to liberty and all of his pursuit of happiness. Now, this is very important as a quote because it's a jurisdictional constitutional law, section 337, citing Fraser versus Shelton, as well as Anthony versus Texas. Now, what's important in this is, did you know that when they stop you and harass you, and they violate your constitutional right, that they're violating your right to life, liberty, and the pursuit of happiness? Did you know that? See, they don't tell you that. Nobody tells you that. See, it's like nobody's really believing it. Are you going to take it to the Supreme Court? Are you going to take it to your district court? You going to bring about a lawsuit? I want to help you. However, it has also been held that statutory authority to prescribe traffic rules is strictly construed and that an ambiguity in a motor vehicle act should be read in the favor of the motor vehicle operator because personal interests are at stake. And that's another quote from AmJur's 2D Automobiles Section 16. Now, the judicial branch is a co-conspirator in the initial legislative, subsequently executive licensing scam. So you see how it goes? Now you're starting to understand how it goes, right? Like, they've already dictated these things. So it's like, well, what's going on? We've got some co-conspiracy going on because they put on a scam, in a sense, by not letting people know. See? But I don't want to call that scam out. I just want to bring the education forward because I don't want to die. You know, I got beautiful family. Private travelers run the risk of being stopped and harassed for not having license plates on their personal property automobiles or a driver's license. But by what authority? You see? By what authority? Clearly, the state has no authority or jurisdiction concerning private affairs. This writing goes back 100 years to get resolutions as to the licensing scheme. The fact that the police use commercial license statutes to interfere with personal affairs is clearly inconsistent with the history of and intent of the driver license. The statutes are void for vagueness as being overly broad and void for want of substantive due process by failing to provide notice of the distinctions in traveling, whereby not clearly and succinctly delineating the differences and establishing proper authoritative and jurisdictional guidelines. Now, quick point. This should show you how bad our school systems fail us. And maybe if you have one in high school, maybe bringing it up to the public education board and saying, hey, is there any eligibility that we could possibly bring back the aspects of learning how to drive back in school, or how to operate an automobile in our schools again? You know, like, that would really be something great for the school system. Why did we take that away? Very odd. And I'll tell you why. Because they wanted to make sure that it was a plot. I'm sure somewhere on the back end, someone was plotting and saying, yo, my nigga, we going to have to take this about the school systems so that we can wipe away this. I literally remember as a kid, man, sitting in the seat looking out the window because that's all I had to do. We didn't have phones back then, bro. So I can literally, and I smoke a lot of weed, but still visually remember seeing on the back of trucks, 18-wheelers, not for hire. And I'd be like, man, bro, they're not driving in the commercial capacity, so they put on that plate so they couldn't get pulled over. They're driving in their own private capacity. Yeah, it's a big rig, but they're not using the roads in the commercial capacity by using goods. And they would literally have on their license plate said not for hire. You know how long it's been since I've seen a real true plate that says not for hire on it? It's very odd. Very odd. Very odd. So let's see here. Okay, quote, a statute is constitutional or unconstitutional in accordance and this is quote, a statute is constitutional or unconstitutional in accordance in the way in which it operates and the effect that it has. So, oh, I'm doing this again. God, I gotta remember to move these screens, man. Yo, check it. So, did you hear what's going on here? And this is going to be Supreme Court case law. So, a statute can be put in place, y'all, put in effect, and it still be unconstitutional. Don't think just because it's a statute that it can't be unconstitutional. I don't know what y'all don't get about that. It's until someone challenges it that it becomes a problem, okay? And I'm sure if you've been following anything in relation to the YSL trial, you're going to see that their RICO statutes are probably going to get some revisions here coming soon because the judges that are ruling on it even thinks it's crazy. The public's going crazy about it. I'm sure it's about to get revised. So the constitutionality of an act depends on its real character and on the end designed to be accomplished rather than on its title for the professions as to its purpose, which may be contained in it. Mere declaration cannot give character to a law or turn illegal operation into legal. Courts should consider the true operation and effect of the law, which must be dealt with on the basis of the practical results which follow its operation, and not alone by the legislative declarations contained therein. As we said in both of these cases, the legislative body cannot change the real nature and purpose of an act by giving it a different title, or by declaring its nature and purpose to be otherwise, any more than a man can transform his character by changing his attire or assuming a different name. Do you hear that? That is so amazing to be heard. Because they're literally telling you, no one can tell you you are doing something that you are not doing. If you are traveling on these roads and you are not transporting any goods, you don't have any passengers for hire. No person can come and say, no, you're driving. You're operating a motor vehicle. Let's read this one more time, okay? We're right here at the very end of this quote that is in State versus Slavin, Bunting versus Oregon. Okay, so Oregon, there you go, guys. Aberdeen Sav versus Lone Assen versus Chase. Jensen versus Henneford. Clark versus Sieber. I mean, this is like literally used in a lot of cases, clearly. And what it says again is, as we said in both of these cases, the legislative body cannot change the real nature and purpose of an act, traveling, by giving it a different title, name, driving, or by declaring its nature and purpose to be otherwise. They can't sit here and say, no, you are driving, any more than a man can transform his character by changing his attire or assuming a different name. Hello. I guarantee you 99.99% of law enforcement out there don't know this. I'm sure that if you bring this quote up in court, no, I'm not going to give you too much then there because then you won't take my course. You better go get that. You better go take the course. You ain't got to pay. It'd be nice if y'all got the book, though. In the case of Attorney General of New York versus Soto Lopez, the court determined that the state must state with particularity the compelling state interest or intent of the policy. Notice the use of the word compelling, not competing. A competing state interest may be found by comparing, for instance, the right of privacy of a sex offender to live at an unpublished location against the state's interest to protect the public and publicize his location for the safety of the public. A state's compelling interests are based on the necessities of national or community life, such as clear threats to public health, peace, and welfare. States have a compelling interest in the practice of professions, and as part of their power to protect public health and safety and other valid interests, they have the broad power to establish standards for licensing practitioners and regulating the practice of the profession. Unquote. Lender Service Inc. versus Dayton Bar Associates, Ooh, that's probably got to be a good, interesting case. See also Munns versus Martin versus Dayton Bar Association. That's got to be a great case to read. Note the correlations of public health and safety. The personal private use and enjoyment of the highways is neither an existing threat, as in the former, neither an impending threat, as in the latter. The state's use of a private for hire classification in one statute and a vaguely written driver's licensing statute is an attempt to serendipitously create or manifest some potential threat generated by all who use the roads and highways. These may be construed as fraud, because the courts and the Attorney General and other statutes have already confirmed that it is commerce that creates the threat. You see what I'm saying there? So the courts have already dictated that it's not the public at large that creates the threat, mainly on the roads. It's all of those now big trucks, lots more people who are using the roads for business. Because if you wasn't using it for business, you wouldn't be on the road like that. You see what I'm saying? Our roads wouldn't be as full. So let's see here. Further, the licensing statutes reach unconstitutional vagueness because elemental in their failure to provide notice. The statutes do not define with specificity a rational basis for including, covertly, the personal and private use of the highways and how it reasonably relates to licensed commercial activity, which would have to be done consistent with the threat discussed above. Quote, the traditional test for a denial of equal protection is whether the challenged classification rests on grounds wholly irrelevant to the achievement of a valid state objective. Unquote. Turner versus Fauci. Fauci. Quote, for a classification to be constitutional, there must be 1, real or substantial difference in kind of persons it defines, and 2, I like that one, it must bear a rational relation to the evil to be remedied. Oh my Jesus. Now we're really getting somewhere. Grace or Gras versus Dealers Transport Company. So, the statute policies challenged are enforced in excess of their historical legislative intent by the police at their individual discretion. The chapter-by-chapter cross-reference search needed suffers only to establish there to be absolutely no link or suggestion that private and personal use of a personal automobile is even remotely implied, and further fails in submission to the narrowing rule wherein, if the suspect statute were striped to its bare minimum intent, could that intent include the private and personal use of a personal automobile, and thus requiring a license? No. Why? Because if the statute had a compelling state interest declaring a threat by private and personal use of a personal automobile, the statute policies could not possibly contain language giving discretionary ability to police. The statute policy is enforced in excess of its historical legislative intent and is per se banishment when the police exercise discretionary functions, whereby penalizing private travel by arrest and imprisonment for the enjoyment of the common highways, which is your life, liberty, which is your life, liberty, in the pursuit of motherfucking happiness. And you ain't gonna take it. And if you do, it's a violation of the Constitution. That's what we not understanding. Like, they've taken away your happiness. I'm not happy anymore because of what you've done to me. You violated it. I'm not in contract with you. I'm dead ass serious. I'm probably going to include that in my suit now. You have damaged my happiness. The pursuit of my happiness, the pursuit of my life, the pursuit of my enjoyment was hindered by you and your threats. Not only were they hindered by you and your threats, in which you thought you was going to get somebody that you was just going to run over because you thought it was your town. Now you done got fired because of the investigation. You got fired again from another police department within a 3 to 3 year time span. Now you got the city getting sued. You gonna call one of my clients? Try and get me fired? Oh my God. Well, that didn't work. It cost me a lot of money. No more commercials. Sorry, y'all, I'm ranting. I need to stop. But you feel where, I guess I'm giving you some play of where it can be applied in real applications. We have to start recognizing these. Some people may sit here and be like, yo, that's stupid. This guy is so dumb. He's going to like try to sue them off of his happiness. Quote, while all property is held subject to the right of government to regulate its use in the exercise of the police power. Figursky versus Historic District Commission. Quote, if regulation goes too far, it will be recognized as a taking. Unquote. I was like, what is going on here? Lucas versus South Carolina. I was so confused at that at first. I was like, huh? What is he trying to say? The Lucas ruling above declares that enforcement in excess of statute constitutes a taking. A taking requires compensation by constitutional authority or restriction, as it may be, by law of eminent domain. Now we're getting into deeper aspects, so please try to follow. If you've not gone back and watched number 1, 2, and 3, please do so. This gets us where we need to be in a nice flow of education. It's for your best benefit. Quote, also included in due process is the vagueness doctrine. Anthony argues the unwritten policy is inherently vague, and the vague statutory language permits selective law enforcement. There is also a denial of due process where inherently vague statutory language permits selective law enforcement. Smith versus Goguen. In order to satisfy constitutional due process requirements, the statute or regulation must provide adequate notice of the required or prohibited conduct. Freeman United States Coal Mining versus Fed Mine Safety and Health Safe Review. So you hear what, let me keep going though. It says, although the regulation must give fair warning in light of a common understanding and practices of the prohibited conduct, the regulation is not required to be mathematically precise. The regulation, though, must be defined with sufficient definitiveness that ordinary people can understand what conduct is prohibited and in a manner that does not permit arbitrary and discriminatory enforcement. They've already dictated you can't just go pulling people over for no bullshit. Violations. Well, I think Fourth Amendment. So, is this another quote right here too? I'm just going to read it like it's not a quote yet. I don't know. The unwritten policy at issue here is not premised on a violation of specific park rules. The policy delegates complete discretion to the police officer, and there are no guidelines for the exercising of that discretion. Do you hear what they're saying? A reasonable person would not have fair warning of what conduct would violate that regulation. Not only are the policy's prohibitions not clearly defined, the policy presents substantial risk of arbitrary and discriminatory enforcement. While there is no evidence pool used this policy in a discriminatory manner, the policy presents significant risk it could be used in such a manner. The unwritten policy is unconstitutionally vague. Due process is ordinarily absent if a party is deprived of his or her property or liberty without evidence having been offered against him or her in accordance with established rules. In reapplication of Einsberg, 654 F2D 1107, 1112, 5th Circuit, 1981. So what's, I think, really important about that, these aspects, so right here what this should do is this should allow you to kind of understand that technicalities, when brought up in courts such as this, get cases dismissed. They could be saying everything that they're saying is correct as far as no insurance and all that. And you bring this into the court, and this alone will have the whole court dismissed, or have all of the charges or violations dismissed. That's really how court is a chess game. It's not checkers, you know. It really is chess. It's about what do you know. If you go out there and get represented, like let's say you go and get a lawyer. You had like some tickets, right? And you know, you had gotten a lawyer and they're saying, well, we'll do a motion to strike or we'll ask for probation. It's like, dude, the first thing you should be asking is, why ain't you filing an abatement? Why ain't you filing a motion to strike? Why ain't you filing a memorandum? Like, what are you doing? File to get this fucker dropped, bro. I'll sit here and be like, oh, you going to talk a deal, Ian? Well, you work for them too? You know, they don't know. They don't study this, bro. It's like if I call... When I went around looking to see if I could find anybody for a constitutional lawyer here in Washington, there ain't nobody out here at all. And it's like, well, dude, I literally can put everything in front of you for you to help do this and pull this off. It shouldn't be that hard. I've already looked up the cases in Court Listener. And they're just like, yeah, man, I've never done those before. That's not my specialty. It's like they can't go across lines. You know what I'm saying? Yeah, I don't know. It's weird. And they don't. Not that I've seen. So, however, quote, however, a court may not assume the legislative pre. Mm, I hate that word. Prerogative and rewrite a statute in order to save it if the statute is not readily subject to a narrowing construction. Without completely rewriting the policy, there is no reasonable interpretation of the unwritten policy that would be constitutional. We are to sever the unconstitutional portion of the unwritten policy and the un- unable unwritten policy is not susceptible to a narrowing construction. Oh, that was so confusing. In reviewing the legal sufficiency of the evidence, we view the relevant evidence in the light most favorable to the verdict and determine whether any rational trier of fact could not have found the essential elements of the crime beyond a reasonable doubt. Johnson versus State. Somewhat similar is the statement that is a rule as old as the law that no one shall be personally bound or restricted until he has his day in court. What happened to that? What happened to no one shall be personally bound or restricted until he has his day in court? What happened to that legal maxim? By which is meant, until he has been duly cited to appear and has been afforded an opportunity to be heard, no one should be taking your private property. Judgment without such citation and opportunity lacks all the attributes of a judicial determination. It is judicial usurpation, and it is oppressive, and can never be upheld where it is fairly administered. Quote, a sentence of a court pronounced against a party without hearing him or giving him an opportunity to be heard is not a judicial determination of his rights and is not entitled to respect in any other tribunal. Until notice is given, the court has no jurisdiction in any case to proceed to judgment, whatever its authority may be, by the law of its organization, by the law of its organization, by the law of its organization, corporation, over the subject matter, that no one shall be personally bound until he has had his day in court. Judgment without such opportunity wants all the attributes of a judicial determination. The definition here given is apt and suitable as applied to judicial proceedings, which cannot be valid unless they proceed upon an inquiry and render judgment only after trial. Unquote. Hovey versus Elliott, 167 U.S. 409 in the State versus Strasburg. Also Dennis versus Moses. And this is also in 12 Am. Juris First Constitutional Law, Section 573. So, when later we discuss tort liability, civil suits, it is important to understand the Fourth Amendment law of search and seizure. The following court ruling is a cumulative summation including some of the most relevant search and seizure case studies this writer could delineate. So, without compounding duplicitous rulings, the law of search and seizure is stated thus. Y'all ready? All my Texans out there, shout out. I'm a Texan. You dig? What's good? Yeah. The application of the Texas statute to detain appellant and require him to identify himself violated the Fourth Amendment because the officers lack any reasonable suspicion to believe that appellant was engaged or had engaged in a criminal conduct. Wow. So there we go. Can we get a round of applause for Brown versus Texas? Can we get a round of applause, please? The application of the Texas statute. So there's a statute in place. I'm going to read this to you and explain this to you so that everybody gets this. This one's going to be the one you get right here. This is going to be the one right here that you're going to get. The application of the Texas statute. So, meaning they've already made the statute. It's in place. And now you got law enforcement agencies out here applying it to detain appellant, so pulling him over when he's not operating in commerce, and require him to identify himself was a violation of the Fourth Amendment because the officers lacked any reasonable suspicion to believe that appellant was engaged or had engaged in criminal conduct. I just said it 5 minutes ago about the Fourth Amendment being violated. They cannot harass you if they cannot prove that you have committed a crime. And I don't care what they state in relation to what level they put a statute on. CBA. If there has been no harm, physical, financially, harm brought to another, there is no way that anything else falls into a crime. Everything else is a violation of a statute, code, policy, or ordinance, which must first have a contractual agreement. Are we there? Thank you. Detaining appellant to require him to identify himself constituted a seizure of his person subject to the requirement of the Fourth Amendment that the seizure must be reasonable. Terry versus Ohio. United States versus Brignoni. Ponce. The Fourth Amendment requires that such a seizure be based on specific, objective facts indicating that society's legitimate interests require such action. Verified complainant! What have I been telling y'all this whole time? Oh, I'm redoing this again. Sorry. Verified complainant. Where is the verified complainant? I'll start over. I'm sorry, y'all. Here we go. We're right here. The Fourth Amendment requires that such a seizure, stop, detainment, be based on specific objective facts indicating that society's legitimate interests require such action, or that the seizure be carried out pursuant to a plan embodying explicit neutral limitations on the conduct of individual officers. Delaware versus Pros, 44 U.S. 648. Here, the state does not contend that appellant stopped pursuant to a practice embodying neutral criteria, and the officers were not justified on the ground that they had a reasonable suspicion on objective facts that he was involved in criminal activity. Absent any for suspecting appellant of misconduct, the balance between the public and crime prevention, and appellant's right to personal security, life, liberty, and the pursuit of happiness tilts in favor of freedom from police interference. Brown versus Texas. How you like that? So all you people out there in Texas that's sitting here being like, "Oh, you can't do this," I actually got a really good guy out there that I keep in contact with, and he posts up and he never loses. Private plates and all, never loses. They give him some bullshit. They make him sit there for about 45 minutes while they investigate. He never loses ever. It's pretty good in that regard. What's pretty cool with him is that they don't even give tickets. It's pretty amazing. So the Brown case above exalts the operational dictate that a policy enforcement employee must have at least one or three potentially overlapping minimal criteria. I'm going to stop switching my screen here in a minute. Y'all going to get pissed at me, I know. We're right here at the top, though. Reasonable suspicion. Reasonable suspicion, reasonable cause, or probable cause. When a policeman stops a traveler on the highway and upon his approach to the automobile, the traveler should inquire if the policeman has a reasonable cause to stop. And the answer he gives should be reasonably, along the lines of operating a business evidenced by the license attached to the automobile. Second inquiry, as to the probability that a violation of some motor vehicle business-related statute has occurred, civil or criminal, is irrelevant. Quote, when construing this act, we are guided by the familiar rule of construction stated by this court in United States versus Miller. When construing provisions under the previous Aviation Act, the Civil Aeronautics Act of 1938, it is axiomatic that any regulation should be construed to effectuate the intent of the enacting body. Such intent may be ascertained by considering the language used and the overall purpose of the regulation, and by reflecting on the practical effect of the possible interpretations. Unquote. U.S. versus Christensen. Oh, that's so funny because the guy over here prosecuting my boy is named Paul Christensen. The history of the invasion of the citizens' right to use the public highways was not attempted in an outright action, but in a slow, meticulous, calculated encroachment upon the citizens' right to travel. And that's what I was talking about earlier. This didn't just come about randomly, bro. It was a slow encroachment. It had to be weaned out generation after generation. Because you're not just going to come across when people are completely free. There would have had to been some major event that we would have known of. And I'm telling you, all the newspapers you can go back and look at. I got a guy that really looks at them deep. Shout out to your archive. What's up, Benjamin? Anyways, that there would if that was to happen, there would be a lot of chaos going in the newspapers. There'd be a lot going on in the case law, and we just don't see that. So what we notice is a slow testing of the waters within states to encroach more and more and more, even to the point where again we've completely eliminated any kind of education being given. Sorry, I had to pause it. I'm back though. So the point here though is that it was a slow invasion, and that's why they brought everything out in relation to the public education school systems. They quit teaching it, right? Because if they're teaching it in any degree, they're not going to be able to generate revenue. And this is in a multitude of ways. You got to really think of it. This isn't just about revenue on tickets. You got to remember that the jails get paid. $125. Oh, I don't know the prices now, but they get paid. Every time they house a person in jail, they get paid for that. They get paid. They go to the state and ask for money for what had to be allocated towards you. So it's a big business. Then you got, the fines and then convictions, right? So, I mean, it is a really big business. But, sorry. The knowledge is here, so we're not putting up with it no more, period. And I know the Supreme Court's going to back us when we take it all the way to it. Any cases that we have from now on, and anyone that wants to have a case taken to the Supreme Court or taked up, let me know, man. If you want to fly me out, I'll be right there to support you all the way, and we'll go all the way with it. That's the point where I'm at now. I'm at the point where I'm comfortable enough to where I can go out and help each and every one of you. Just get me a plane ticket and let's go. Let's go. You got a place for me to lay my head? The history of the invasion of the citizens' right to use the public highways was not attempted in an outright action, but in a slow, meticulous, calculated encroachment upon the citizens' right to travel. Quote, disobedience or invasion of a constitutional mandate cannot be tolerated, even though such disobedience may, at least temporarily, promote, in some respects, the best interests of the public. Unquote. Sloat versus examination. Quote, economic necessity cannot justify a disregard of constitutional guarantee. Unquote. Riley versus Carter. Quote, constitutional rights cannot be denied simply because of hostility in their assertions and exercise. Vindication of conceded constitutional rights cannot be made dependent upon any theory that it is less expensive to deny them than to afford them. Unquote. Waston versus Memphis. So, the state cannot demand from the sovereign people what it never had a right to. Then there's the issue of public policy. Public policy, aka statute, is just that. Public policy, and does not transcend the private. However, if this argument is used, it too must fail as. Now, why is that? How can public policy not override the private? Because it requires a contract. That's why. Nothing will ever be over you. Nothing. No state government, no police agency, no federal agency, nothing. Nothing will ever be above you. You will always be the top. Always. Okay? So I think I'm trying to keep y'all at hour points on these ones. I don't want to take y'all too long past the hour because I feel like y'all are not going to watch all this. Some are like, oh no, give it to me, Cameron, I want more. But I'm going to keep them at hours. And this is a good moment to segment into. Let me see. Into the aspect of the course. You already know what's up, y'all. What's up? Okay, so the course. Y'all come get that course. It's free now. All you got to do is put in your name and your email. Okay? Then what you got to do is, if you want, after you get done with the course, or if you want to get the book first, that'd be cool too. Because you can give the book as like holiday gifts. So that's what's pretty cool. You could give it as an audiobook, or you could give it as a hard copy. So the holidays are coming up, and this is a really good gift, man, no doubt. It's literally you're giving someone the knowledge. Like knowledge is so wealthy. Like knowledge is worth so much more of its weight, than gold. It really is. Because with this knowledge, it's forever. You always have the knowledge. So what's cool is that right here you can buy the audiobook. It comes with the ebook, PDF, and it comes with an audiobook. And then you can also get a hard copy, y'all. I got it to where y'all can get a hard copy. I didn't put it on Amazon though yet because Amazon takes like 40%. They're crazy. So, but that one's on that. Okay. So I just wanted to let y'all know, get ready for part five. We're going more into public policy now and statutes and just those details. Hopefully you're getting a good grasp. Y'all give me some of your comments, your questions, your details, and we'll just keep it going. Okay, we're gonna finish this bad boy. I told you it's long. I love you. Y'all be safe. We'll talk later.